Hello, distinguished friends and colleagues. This is Stuart Hamilton, the Pro-Life Activities Coordinator for the Archdiocese of Louisville, Kentucky, serving under Deacon Stephen Bowling. And this is 5 Minutes for Life. We'll take 5 minutes to discuss one topic, one ministry, or one event that affects the pro-life movement here in the Archdiocese of Louisville. Well, this last Monday, June 24th, was the second-year anniversary of the Dobbs Supreme Court decision, which overturned Roe v. Wade and returned the issue of abortion back to states. So I thought I should update you on some important things dealing with abortion law. I'm going to do that in 3 phases. First, we're going to talk about a couple of controversial Supreme Court decisions that were recently handed down. Then we're going to talk a little bit about what's happening at the federal level, and lastly, the local level. So without further ado, let's talk about the Supreme Court. And I'm going to be reading a little bit more than usual off of the script here to make sure I get everything right. A couple of weeks ago, the court did hand down a decision in the Food and Drug Administration versus Alliance for Hippocratic Medicine. Now, if you recall, this case was highlighted by the USCCB for prayer. Essentially, the plaintiffs in the case are suing the FDA for deregulating the abortion drug mifepristone. They did that back during COVID times. Essentially, the FDA said that you can mail order the abortion drug and you don't need doctor supervision. Well, the plaintiffs argued that that was very dangerous to women without doctor supervision, and it could even open doctors up to future lawsuits. Well, unfortunately, the Supreme Court threw the case out on procedural grounds. So they didn't really judge the case based on the merits of its argument. They basically said the plaintiffs lacked legal standing. In order to argue that people will be harmed by this, you have to be someone who is harmed by this, and they really had no one like that in this case. So yes, it's unfortunate, but maybe in the future, if we do find someone who's been harmed in this way, we can bring the case back up. Much more disturbing, however, was the decision handed down yesterday in the Moyle versus United States case. Now, what happened here is it has to do with the way that the federal government is applying the Emergency Medical Treatment and Active Labor Act of 1986. Okay, now that act had nothing to do with abortion. It has everything to do with emergency room access. But in 2022, after the Supreme Court repealed Roe v. Wade, U.S. Secretary of Health and Human Services stated that under the act, an emergency room doctor must provide abortions to pregnant women if it is determined that the abortion constitutes a stabilizing treatment, whatever that means, under federal law. Well, Idaho, which has the most restrictive abortion laws in the union, challenged this. It went through the court system all the way up to the Supreme Court, and unfortunately, the Supreme Court dismissed Idaho's appeals as improvidentially granted. Essentially, they said, there's a case here. The Secretary of Health and Human Services can apply the law in this way. And what does that mean? It means that doctors who are working in emergency rooms have to give abortions if the woman is making a claim in the emergency room that it's necessary for her stabilizing treatment of, say, her fertility or any other number of things. And if the doctor doesn't do that, then that case will probably be prosecuted by the DOJ. Now, this opens up a whole Pandora's box, even for Kentucky and for all the other states that have made abortion illegal, even the ones that have made it illegal, except in cases of emergency for the woman's life. We'll just have to see how this plays out. But keep in mind here, in all of these cases, it comes down to how the federal administration is currently handling the law. And so that brings us to the federal level. We have here how the federal government is going to implement the Pregnant Workers Fairness Act. Okay, now this act also had nothing to do with abortion. It was meant to secure rights for women who were pregnant. But when the Federal Equal Opportunity Employment Commission published regulations for how the law would be implemented, it basically stated that employees must provide paid leave for women who seek an abortion, or paid leave to women who have complications from abortion. So once again, it's not the law that's the problem. It's how the current administration is applying the law and regulating the law. Well, this actually had a lawsuit brought, and one of the plaintiffs in the joint lawsuit is the USCCB, saying that it goes against religious liberty to force religious institutions to provide paid leave for women who get an abortion. Well, a Louisiana judge basically granted a temporary injunction while this lawsuit goes through the court system, and very likely it will also go to the Supreme Court. Now, this comes on top of the way that the DOJ has been aggressively defending the Freedom of Access to Clinic Entrances Act, which essentially is saying that women have rights to access abortion clinics. The DOJ has been arresting sidewalk counselors all across the U.S. who violate these ever-expanding buffer zones. So what's the common theme here? Well, essentially, the current administration is handling the laws in such a way that they are advocating wherever possible for abortion rights. This is very problematic and an important reminder that who we elect at the federal level actually matters. It matters a great deal. But what about the local level? Well, thanks be to God, abortion is still illegal in the state of Kentucky. It is still overturned. Now, I've mentioned multiple times that abortions are still happening because of access to mail order abortion drugs. But as far as surgical abortions, they are still illegal, and we can thank God for that. But if we want it to remain illegal, we must be vigilant in prayer and in activism. We need to push ever increasingly to get an amendment to the Kentucky State Constitution, which says our Constitution cannot be read in such a way that abortion is seen as a right. Okay, that is definitely all the time I have for today. Remember, every human life is worth fighting for because every human life has dignity and value in the eyes of God. If you like what I'm doing here, smash that like button, hit the notification bell to let you know when a new video comes out. And if you want to read more about these cases, I'll put links in the description of the video. God bless. We'll see you here next week.